We are welcoming Professor Carrington to Constitutional Chats today. He has a class that runs a little late, so he has sent his comments in. We're going to play them now, and by the time we finish his opening comments, Professor Carrington will be on for us for the question and answer portion of our program.
Good afternoon. Very happy to be with you all here as part of Constituting America and continuing the very important conversations that you all help with so that we as citizens can think about what it means to be part of our constitutional republic. And we have obviously a very important issue at stake today that we're talking about, presidential immunity. It comes, for those following the news, from former President Trump being indicted for actions related to the events of January 6th, 2021. And this is obviously a contentious question for contemporary partisan politics for the 2024 election. And those matter, but we, as I know we normally do in these kind of forums, are going to be focusing on the broader constitutional matters, the broader issues of how our system does work and should work. And that's where I want to lead with. President Trump has claimed complete immunity from prosecution for all official actions made as president, meaning nothing he did officially as president can ever bring him up for any kind of legal repercussions, and that this includes all of his actions on January 6th, that those were all done as part of his official duties as president of the United States. Now, so far, the DC Circuit Court has rejected that blanket immunity, that complete immunity, and the Supreme Court has taken it up and will hear arguments this month about it and come to a decision regarding it sometime this summer, probably toward the end of June. And the bigger picture that I think we would be helpful to discuss and that will really help other people have the conversations that they need is to obviously not just look at the particulars of this case, but to ask the serious, broader questions about presidential immunity in relation to three categories. One, the concept of the rule of law to which our Constitution commits, and the other, two subsets of the issue of separation of powers. One, what does the president need in our system to do his job properly? And two, what do the other branches need to properly do their jobs under the Constitution? And I'd just like to outline these broader issues as a way to set up our conversation going forward. So first, about the rule of law, which is, I think, the place we need to start. We, if we're going to be in any kind of community together, have to live according to rules. And if not, we live in kind of an anarchy. And these rules by which we order the way we live together need to not be based off the whims or fancies of one person or group of people. That's the rule of human beings and has been the road to tyranny, has been the road to chaos and confusion, if not tyranny. And so what we really want are settled rules made ahead of time before they're applied, coming from the legitimate fount of political authority, which for us is the American people, and applied, enforced, and understood according to procedures made ahead of time for that purpose. These rules, we call them laws, form the standard for our actions, government actions, and therefore a means of accomplishing the common purposes we want to see done together. So the rule of law means we channel the rule of the people through the Constitution and through the Constitution as a law by means of the rules that we make. So this rule of law means that no woman or man is above the rules we make, regardless of their authority, their fame, their wealth, which then obviously applies to those in public office. Any person, including governmental office, is subject to these rules, must be held accountable to them, whether they are lawmakers, law enforcers, law interpreters, and appliers. At the same time, those who are doing those jobs, those carrying out or making of the laws, need to have the proper tools themselves to make the law rule. They need to be able to um, create and enforce laws and rules so that we have them and so that they do their job properly. And so the other two needs that I mentioned, asking the question of separation of powers about what does the president need, what do the other branches need, really come out of how they realize, constitutionally speaking, this fundamental concept of the rule of law. So thinking about the presidency first, what does the president need? And then how can we think about questions of immunity in relation to that need? He is given the executive power of the United States by Article 2. And the essence of executive power is the ability to carry out or enforce the laws that exist constitutionally or by Congress, whichever it is. And this power to make sure that they are, as the Constitution says, faithfully executed, the laws, I mean, is a deeply important power. Federalist 70 says, without energetic, good enforcement of the law, you actually don't have a real or effective or good government. Because what's the purpose of laws? The purpose of laws is that they be obeyed, that they be followed. And if you don't have good enforcement of the laws, you have basically good wishes that don't protect people, that don't limit government. And so therefore, we want an executive power that is able to effectively carry out the laws, even if at the same time we don't want the president and the officers under him to be able to go beyond the laws. So any questions of immunity is going to ask, are there special needs for the president that needs to be respected so he can carry out the laws while not going to the extreme of making sure he himself is not subject to them? At the same time, the other branches have needs as well. The legislative branch needs to be able to make effective laws, and to be effective, they do need to apply widely. They do need to apply to not just themselves, but other government officials. So that needs to be taken into account. But in this case, we need to particularly to ask the question about the judicial power, that the president is being prosecuted, that turns into a judicial proceeding. And how is it that the judicial branch, what tools do they need to effectively carry out the administration, interpretation, and application of law? And to what degree would claims of presidential immunity interfere with their ability to do their job properly? So those are the kind of big questions we have to ask about the rule of law and the separation of powers to, I think, really think about the question of presidential immunity. And historically, we can get into these. There have been instances where the president has been given special treatment so that he can carry out the law properly. But there have also been instances where that has been limited and the rule of law has applied to him as it does normally. So I think that what we need to be looking into in this particular case is to what degree can we balance these different, distinct, but interlocking ideas? And again, to uphold the idea that the Constitution is our law, that we are committed to the rule of law, and that we need to make sure our system is functioning properly so that we have a government where we recognize, as Federalist 51 said, that men aren't angels, so we need laws to limit behavior of individuals, but that the government isn't run by angels. Therefore, we need limits on how the government administers that law. And so I'm happy to continue this conversation with you all, and hopefully we can come as citizens to a better and fuller understanding of these very important issues for our republic and for ourselves as Americans going forward.
Thank you, Dr. Carrington. And I know Dr. Carrington is getting on and joining us very quickly. He's just wrapping up a class at Hillsdale. And I thought that we might talk just a bit about our thoughts on what Dr. Carrington shared with us. He just texted and he said, yes, almost to my office. So I'm just going to throw it open here to our panel until Dr. Carrington gets on and joins us.
Well, I have two questions, and I can't wait to ask him. And and I'd be interested to hear what everybody on the panel has to say as well. This is Janine, obviously, I'm speaking. There's a clause in the Constitution that says that presidential or elected officials cannot be held liable or tried for a crime when they're in office, but they can be when they get out of office. Does anybody know where that is in the Constitution?
I think we may have to wait for Professor Carrington on that one.
Yeah, because it's in the Constitution somewhere. And good, he's here. Oh, yay!
Well, we'll let you lead.
Perfect timing. Hi, Professor Carrington. It's Janine Turner.
Hello. Thank you all for letting me join you.
Oh, well, thanks for your overview that was recorded. We appreciate that. And for rushing from class to the Zoom here. Okay, I'm ready. I just asked a question of all of us on the panel, and none of us knew the answer. So I'm going to go to fundamental questions regarding this Supreme Court case and what President Trump is claiming, because I'm very confused about that. And of course, we have a lot of students as well. He's claiming immunity, but based off what? Which part of the Constitution is he claiming this? And then I would like for all of us to put it on the screen where, Lacey, please, Lacey, our expert, that clause that President Trump is referring to, unless he's just going for executive privilege. And that's what I'm confused about. But the other thing, my second question for you, I remember from the days of studying the Constitution and writing about the Constitution, my daughter writing the book, I believe there is a clause in the Constitution that says, because the king used to just go wipe out the entire Congresses and say, I am, you all have broken the law, and now the whole Congress is now adjourned and none of you can come back. So to avoid that, there's a clause in the Constitution that talks about if while they're in office, they can't face legal action, but they can once they become citizens, but they can't do it while they're in Congress or even as a president. I need someone on this panel to find that for me, because I know it exists. I just may be saying it incorrectly. So is everyone looking that up very quickly? So I'm kind of confused because I know there's something that said that you can't, if someone says something in Congress or in the executive branch, they can't just say, you're guilty and you're out. But they have to sue them later. And I'm not talking about impeachment, but there's a clause in there. So maybe not, and I'm dreaming it. But that's my question also. And I'm really confused about what President Trump's trying to claim here and what he's basing it on.
Right. And you're thinking on that one, the speech and debate clause, which is I think Article 1, Section 6, where there's an attempt to limit the you're right, where the king would arrest members of parliament to try to get the vote totals to what he wanted, and therefore not give them the freedom to speak and debate as they wanted. I don't know how much that would be pertinent here for the president. However,
could we just read that clause, Professor Carrington? Hang on, Lacey, would you put that clause up on so we can all read it? Because I'm really curious about, before we move on to the president, what this means. And I thought it was a really good aspect of what our founding fathers did.
Yeah.
So where is it here? Let's look.
I think it's the first section of Article 1, Section 6. I mean, I have
Clause 1.
Yeah, Clause 1.
They shall in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses. I'll put that red back, it was nice. And in going to and returning from the same, or for any other speech or debate in either house, they shall not be questioned in any other place. I think it's really fabulous for all of us to learn about this. Could you please describe, except be privileged from arrest? Okay, so they're privileged from arrest.
Yeah,
But
and
what does this mean? But when they get out, can they still have a civil trial against that? I mean, what does this mean?
yeah, and obviously there's exceptions for treason, for felony. For felony, you can't go, commit murder and say this clause protects me. But it does protect you from misdemeanors as we understand them now, and other less than treason or felony crimes. And what it's meant to do, again, is to not allow the executive, the king in the old case, the president now, to use enforcement of the law, especially accusation of crimes or violations of the law, to be a means of removing or intimidating legislative officials from free and open debate about policy. And so the idea is to not allow the executive to use the law enforcement power to intimidate the legislative branch, and therefore to allow the two branches to mutually check each other, inform each other. And I will say where this, I think, does connect in one way is the underlying assumption here is that each branch needs to have the safety from the other branches to do its job without fear of repercussions or recriminations from other branches. And the executive needs that as well. And that is part of the president's. I'm happy when we're ready to at least lay out what his former
Yeah,
president's
can we
basic
go
arguments would
back
be.
to if we
Yeah.
could go back to the clause, put it up one more time, Lacey, because please and thank you. It says felony. What were those other three words? It went away kind of quickly. I think Lacey's going to put it back on the screen. It's felony, what and what?
Treason, and actually I lost the clause too. Felony, treason.
Here it is. Oh, it just went away. I can't see it. Okay, it's just okay. Treason, felony, and breach of peace, privileged from their arrest during the attendance of the session.
Yeah.
So I think they can be arrested outside the session, but they can't, or maybe their term, I'm not exactly sure what that means, but they can't treason, felony, and breach of the peace be privileged from arrest. Okay. So that's really interesting. And thank you for taking the time to do that. I think that's a great lesson for all of our students. I thought that was really a cool clause. And at least I didn't know what it was, but at least I did remember it was in there. You know what I mean?
Yeah.
So now, and then I looked at the privileges and immunities clause in the Constitution. It is, but I'm not sure. Is that what, or is he trying to just say he has a privileged? He's privileged. His information is privileged, or is he trying? President Trump, former President Trump, or is he trying to equate that to the Constitution?
So his basic argument is to say that he is immune from any prosecution, either criminal or civil, for any action he takes as president. So not private actions, but any action he takes as president of the United States, he cannot be prosecuted in any way, either civilly or criminally. What
is he basing that on? Is he basing that on the Constitution?
He bases that on three grounds. And the first is he claims that it would violate separation of powers for the judiciary to investigate and convict him, because it would be one branch basically disabling the office holder of the other. The second is based in Article 2's vesting clause, the idea that the executive power is given to the president. The argument of really all forms of presidential claimed immunity or presidential executive privilege is the president needs some particular protections to do his job. And if he was allowed to just be prosecuted as everyone else is, it would handicap his ability to carry out the duties of the presidency. In other words, it would leave the executive branch too hampered, and therefore the laws would not be faithfully enforced. And then finally, the other argument that
wait, before you move on,
Yeah.
before you move on, and I'm sorry I'm interrupting you so much today, but I'm just trying to get this super clear, and it's such a cool
Yeah.
topic. Can we pull up that vesting clause? I think it's important for our students to see this vesting clause. I always love when to actually look at it in the Constitution. So what article and what is that? Where is that vesting
It
clause?
is the very opening of Article 2, Section 1.
Okay, so Lacey's getting that for us. And what do you have it there? You can read it while Lacey's getting it.
I've got a little pocket Constitution next to me, so I can
Look at you.
Oh, there we go. The executive
I have
power.
one in my desk.
Yep. Oh, I see it's up on the screen. Yes, the executive power shall be vested in a president of the United States of America. And so one of the arguments is, what is the executive power? And I know I was noting this in my opening recorded statements. It's the power to enforce the law, to take the laws that exist and apply them, and just make sure that they actually offer the protection and benefits that the laws are supposed to give. And the idea is, if the president is given a duty, then he is given all the reasonable means to fulfill that duty. I mean, if you're thinking with students, imagine if a teacher said, you need to take a test, but you're not allowed to have a pen or a pencil or a computer. You're not allowed to have the questions. You're not allowed, and all these other things. And the idea would be, well, you've told me I have to do something, but you haven't given me the means or permitted me the means to actually do it and do it well. So former President Trump is arguing that since the Constitution gave him the executive power of the United States, if there are actions that other branches or other people would take that would make it so he just couldn't do his job, then he has immunity from those things to make sure that his constitutional duty is fulfilled. So that was one of his arguments.
And what they're trying to do, Professor Carrington, the reason he's taking this to court is because what are they asking of President Trump? They want to see all of his records, and he's saying, I don't have to show my records to you or my notes because I had the vesting power. What is the actual suit, and what is it? I mean, I know the suit is whether he has immunity or not, but why is he? What are they prosecuting him for? What are they trying to get from him that he's gone to the Supreme Court for this?
Yeah, and in previous instances where this has come up, it's been a lot about giving information that the president thought he didn't have to give. But no, here the president is being prosecuted criminally, and Jack Smith, the prosecutor that is bringing these charges, is saying that former President Trump, is criminally responsible for the actions that took place on January 6, 2021. In other words, he is guilty of insurrection and aiding and abetting insurrection, guilty of aiding and abetting other criminal activities that are claimed to have taken place that day. And so this is different, where he is facing, if he's prosecuted for this successfully, jail time, fines, other things. And he is arguing that.
But what is he asking that he doesn't want to give? What does he want immunity from? President Trump.
All charges should be dropped entirely, and he should not ever be subject to even a trial for these accused crimes, because if this was done as part of his official duty, his argument is, if it's part of his official duty and other branches can prosecute him criminally for doing that, then it will hamper future presidents from vigorously doing their job as president, is the claim. So yeah, he's claiming nothing I do publicly should be brought to trial. I should have complete immunity from prosecution, not just from giving information. Yeah.
Okay, Professor Carrington, you've been great. I need to pass this on, but I want it in 10 seconds, because I think I've hogged a little extra time here. Can you tell me what the third thing is? He's trying to say separation of power, Article 2 vesting clause, and what was the third?
The impeachment judgment clause, and his argument is since he was impeached but then acquitted for basically the same scenarios in his second impeachment trial, therefore, because he was acquitted by the Senate, he cannot now be criminally prosecuted by a judicial branch or by the judicial branch because that would be double jeopardy. That's his last argument.
Interesting. I think that's the best argument right there. Really interesting. Fascinating. Okay, thank you. I'm going to pass on to my team here. Thank you so much. I admire you greatly. I thank you for all the work you do for our foundation. I appreciate it.
Oh, thank you. And I could say before others jump in, just to say, the district court rejected all three of these arguments. So if anyone wants to come into that question, the district court below the Supreme Court, the DC Circuit Court took up all three of these and went through them and found all of them wanting. We can talk about why and why the Supreme Court may decide differently, but just as far as these things have been so far debated somewhat, just not all the way up to the Supreme Court.
Great. Thank you.
Professor, thank you so much for being on. This is such an important question to talk about. I wanted to ask, and feel free, I can ask another question if this isn't your area of expertise, but I wanted to take a bit of a comparative politics approach and look at how other countries view presidential immunity. Are there any other countries comparable to the US that just completely have the chief executive be immune from prosecution for anything they do in office? And particularly, I'm interested in examples of democracies because I could see in personalistic regimes where they might have, or just a very strong executive where they would kind of have themselves be immune from prosecution because of force. But I'm curious, are there any other kind of pluralistic democracies akin to the US that have full presidential immunity, or would this be like, if this argument goes through, would the US become the first country to have this?
That is a little bit out, but I will say what I do know of this, which is I don't know if this would be utterly unique, but it would be pretty extraordinary to give this blanket level of immunity. Now, do most even democracies give some leniency and some level of immunity to public officials? Yes, but really the only cases where you get a complete blanket immunity tend to be in monarchies. So Great Britain, you could never prosecute the king, Charles I being the exception that proves the rule. And really you had to prosecute executive officials. You had to prosecute the advisors and servants to the king, not the king himself. But the reason you did that was something that just doesn't come up in our system, which is the king is the representation of our sovereignty. And the idea that you could sue the sovereign is basically to make the sovereign subservient to himself, logically. But we, the people, and the Constitution is sovereign here, so no one public official is, so they can all be subject to this. So this, I think, would be fairly unique, even if I can't claim exhaustive knowledge of the history of representative governments on this score.
Thank you. That's a very interesting perspective. And then I guess I was curious, since we often in this organization talk about like the founding fathers' view on things. What do you think, first of all, did the founding fathers have any debate at the time of inception about this topic of full presidential immunity? Again, like outside just physically being in office. And what do you think they would have said about this? Especially, I mean, what stuck out to me is you saying how the other example of that would be a monarchy, and we kind of had the Revolutionary War as a way to distance ourselves from that system, but also we do retain some aspects of that. So just what do you think the founding fathers said, and would there have been debate between them on this issue?
I think there would have been debate about applications, but I think the broad consensus was something between treating the president as if he is no different than any citizen in what he's doing, and a kind of blanket immunity that keeps him from any prosecution. And one of the ways that is almost necessary is to say that why would you have first the impeachment clause at all if the president could not be held accountable? And why would you specify in the impeachment clause that this doesn't mean that he's not also subject to prosecution in the judicial process as a parallel matter? At the same time, the idea that the president doesn't have to do everything the other branches ask, or that he might have some special treatment so that he can make sure he does his job, goes all the way back to President Washington and the House of Representatives demanding private communications between him and John Jay for the John Jay Treaty of 1795, where he basically said, I don't have to do that because there are special powers I need preserved so that I can do my treaty negotiating job properly for the good of the country. So I think the broad consensus would be the president needs some means that are special so that he does his job properly, but to say that he is completely immune from all prosecutions is another matter. And the last thing I'll say on that, just to be clear, is none of these questions has anything directly to do with whether you think President Trump is guilty of those crimes or whether he acted responsibly or irresponsibly. This whole question is whether we can adjudicate that question in a court of law or not. And the degree of his immunity. You could decide that he's not immune from these and decide he's innocent. You could decide he would be guilty if he could be prosecuted, but he can't be prosecuted. Those are kind of two separate questions. But I would say that the founders would have said not completely immune, but not treated exactly like any other citizen, because he is the one branch that is where the entire power of that branch is lodged in one person. That doesn't happen with Congress. It doesn't happen in the judiciary. That is the one branch where one man or woman is given all of the power of that branch. All other officers are getting it delegated from him. So the idea is that's why you got to treat him special and different, because he's the only one where you could handicap or eliminate the whole branch if you undid the power of one person.
And then has any other presidential administration tried to make this argument before of blanket presidential immunity?
Not on criminal prosecutions, but the Nixon administration and the Nixon presidency did try to argue that on the question Janine was asking about information was the idea that the president, for national security and other reasons, has absolute privilege to determine what other branches or the American people can see about private communications, internal deliberations. So that wasn't immunity from prosecution, but it was immunity from being made to give information for others. And I'll just say the result of that was the Supreme Court saying, no, but the president can be treated specially again, but it's not a blanket immunity claim. And interestingly, they did so for separation of powers purposes. They actually said, we've got to respect the president's job, but we got to respect our own job. If the judiciary is going to prosecute anybody, including administration officials, they have to have access to enough information to decide whether they can prosecute or not. They have to have the information to make sure the trial is fair and all those things. So we have to work out making sure we have the information to do our job and the president has the protection to do his job. And that can be kind of a delicate process when these kind of criminal or other investigations are going on.
Yeah, no, that was what stuck out to me about the argument that former President Trump's team was making about this ability to prosecute the president violating separation of powers. Because I think, as you said, you could just as easily turn that on his head and say, what about checks and balances? Couldn't a blanket presidential pardon from any wrongdoing committed in office, couldn't that violate checks and balances, especially because this case, to me, seems to be related to the executive interfering with the business of Congress, which is the certification of the Electoral College on January 6th, that gets lost, that was what they were doing on that day. But to me, it seems like this case could be said that this case is actually about a lack of separation of powers in the direction of the executive overreaching on the constitutional duty of Congress. So it just is interesting that the team is using the argument of separation of powers in this case, because it seems like it could just as easily apply to his opposition. Anyway, that's just my 2 cents. But I was curious as well about why the Supreme Court decided to take up this case when it seems like the lower courts were pretty, relatively unanimous. Do you think it's because justices might see merit in some of former President Trump's case, or is it more just this is such a contentious issue that they feel the need to rule resolutely on it one way or another?
I think the contentiousness of it probably did play a role in the fact that it involves a person who's not just the former president, but a contending candidate to be president again, which means this trial could happen to a sitting president, not just a former president. The other is the court, I think, is interested in the separation of powers question, that there's an issue of making sure that each branch is able to do its job, that those in positions get worked out. And the idea is this is sort of a new realm that hasn't really come up, and they want to make sure that the proper balance is struck between protecting the presidency and protecting the other branches and protecting ultimately the rule of law. And I don't think they want to leave it up in the air because there's just too important of interests going on here. So I think that's also why they're taking it up.
Well, thank you very much. I've learned so much, and I'm eager to see what happens. Might have to bring you back or something. But now I'll pass on to Jewel and Jordan for more questions.
Yeah.
So thank you for this deep show, these complicated questions and everything. First thing that I guess sort of sticks out to me as a question that's not directly related to the immunity is just that we're hearing the case in immunity. It's wrapped up in a case against Trump based around charges of interfering with Congress and even up so far as insurrection.
Mm-hmm.
There is half of the country accepts a premise that's never been proven in court, that there was an insurrection. It's never been legally ruled on that did happen, and yet there is a presupposition in nearly all of Jack Smith's arguments and people who are defending those arguments that is what took place. And so I'm wondering, with Trump's immunity case, is the reason why this was brought this way because their legal team foresaw that there was a seeming presupposition, didn't think there would be a fair trial, so this is a workaround that they were going to attempt in the face of a prosecutor who seems to be presupposing a crime and the guilty verdict of that crime as if it has already been ruled on. Because the language is strange when on cable television and even from the prosecutor's team, that as if the guilty verdict has already come and that the definition of insurrection is not legal, when I believe in our founding documents that it would be a legal distinction, not necessarily an opinion.
Right. And this is where, I mean, you could say the lawyers are throwing every argument out you can. And if you can make it so you can't even go to trial, why not not have the risk of a trial at all? But I think this, on a more principled level too, goes back to what something I was saying to Tova at the end of our discussion, which is, it's one thing to determine whether the president can be prosecuted at all. It's another thing to determine whether he is guilty or innocent of that which he is accused. And so I could very well see the court saying the former president could be prosecuted for this. He doesn't have blanket immunity, and then him winning the case. And if it does come to where he can be tried, it is a completely separate question whether these are bad definitions of the crimes for which he's been accused or whether they're good. It's a different question as to whether the facts comport with the law. And so that's one where you could say, yeah, the president could be prosecuted for criminal things, and this doesn't reach the level of it. So that could be very much the result. And so to say that former President Trump could be prosecuted is not to say he is guilty. He should have as fair a trial as is possible. The prosecutor should be held to the standard of the law if it comes to that. That is an entirely separate question that one can come to a different conclusion as opposed to whether he can be prosecuted in the first place. He could be prosecutable but completely innocent. So one shouldn't confuse the answer to one as the answer to the other, and one shouldn't assume that he's guilty and that that's the only reason he's seeking immunity. They're two separate questions.
I am having a lot of trouble looking at this, honestly, in a very simple way. That through all of history, we've had presidents that have never been tried, never been prosecuted for anything. And looking at this, I have to look at it and say to myself, this is the worst thing that any president has ever done in our nation's history. And that seems like you mean looking at it, if this is the one thing that goes to yes, criminal the trial. one thing that goes to, I was unclear. My apologies. This would have to take the place, but even the discussion of it, this would have to be the worst thing that any president in our history has done, and that seems like a hard task to convince me of, that this is just by far the worst thing and the only time it's been necessary to really try to prosecute a former president.
So
was there an immunity clause almost in practice, but not in, that's the way that's the custom of our country, even though we don't see it explicitly written somewhere in that language?
Yeah, well, obviously the parallel in the past is Richard Nixon, who was, before the final decision was made about potentially charging him, a pardon by President Ford. So we don't quite know what would have happened if he hadn't gotten a presidential pardon by the next president. There have been presidents who have been prosecuted civilly in the past. So Bill Clinton is an example. He was accused of harassing a woman while he was governor of Arkansas, Paula Jones, and the Supreme Court actually unanimously argued he didn't have immunity from being civilly sued. They did say the president should get some deference as to when he shows up for trials and other things, but there is precedent as far as the idea that others have been brought in that way. There were instances where JFK was almost brought to trial, but then the charges were dropped or settled in the past. So you're right that we've never had a criminal prosecution of a president. The tendency has been, even if there were some credible accusations, to say that the cure was worse than the disease. The political hot button of touching such a high-ranking political figure has tended to be something people have not wanted to touch. But there have been instances in the past, Bill Clinton and Richard Nixon, where former President Trump's not the only one to have any judicial process brought before him or brought against him. But yeah, it has been the exception, not the rule, I think, partly for that reason, and partly for, I don't want to get into the lives of every individual person, but partly too from not even having a level of legal controversy of this magnitude for other past presidents as well.
I think it's very interesting to think of what one of Tova's questions were towards the end of our founding fathers looking at the country today, but also know that this probably wouldn't be the first thing on their mind if they were looking at our country today. They'd be looking at so many different things that would blow their mind. But one of my questions would be, that without a sense of immunity, and we know that other members of Congress have been prosecuted for different things, and we have had criminal prosecution of government officials, but without any sense of immunity, the type of lawfare that will continue in the future, and our founding fathers certainly wouldn't be in favor of our government acting with impunity. In fact, that was everything they did not want. But at the same time, our founding fathers in general were not supportive of the French Revolution for its lawfare that turned into mob violence. Now ours hopefully won't get there, but we will, I would think, see a lot of increased lawfare and the attempted prosecution of elected officials across a broad spectrum because it can achieve a political purpose. So what are your quick closing thoughts on that? And thanks for answering all our questions.
Yeah, I'll say two things. One, I do think it is a bad thing, and that should be obvious, that to politicize the judicial process. The judicial process should be the most removed from day-to-day politics. It should be about, that's why we, by the way, don't have elected judges in the US Constitution. We want the law to be applied fairly and impartially as possible. And the idea of using political prosecutions is a dangerous precedent. I also, though, think there's a chance that blatantly political prosecutions, whether this one is one or not, tend to backfire. They tend to expose, if they really are merely partisan, they tend to expose their own weaknesses, and they tend to delegitimize the accusers even more than the accused in the long run. So I think there could be, if that's really going on, if you let the process play out, some genuine snapback, and people will maybe realize this is not only an unjust thing if you're doing political prosecutions. Again, I'm not saying whether this is or not, but you will see that it's actually not in your political long-term interest as well. And I think that would be for the better, that we don't want either side engaging in that, regardless of the merits of this or any other lawsuit.
Thank you. All right, our time is up, and I pity that Kathy has to try to fit in some of these audience questions, and here we go.
Yeah, no, we've got a lot of great audience questions. And first up, one of our listeners writes in asking if you could go ahead and elaborate on the lower court's decision and then on potential Supreme Court decisions.
Yes, and I would encourage people to read, to the degree they have time, the DC Circuit Court opinion. It's not as, law speaky as people sometimes think. I think a regular thoughtful citizen could understand it. And the court gave a lot of deference to the general idea of the presidents being allowed the deference and means to do their job. But ultimately, I think they said, and this is kind of repeating some things I've said, they said that you can't not hold any official accountable to every official must be held accountable to the law. The judicial process is part of that. So presidents have to, at least in theory, be subject to some judicial process. The need to do the executive's job, they said that might give some immunity, but not blanket. And in this case, the idea is the particulars of January 6th were so hopefully unrepeatable that it's not going to fundamentally undermine. This is not the same as prosecuting a president because he didn't conduct foreign policy properly, which could completely undo a major part of the president's powers. And third, impeachment and judgment clause. The judicial process is not the same as the impeachment process. Each should be able to make their own determinations. I think the Supreme Court will probably come to fairly similar conclusions and probably say the president doesn't have blanket immunity, but they will give significant deference to the president in particular questions on this. So if anything, I think that President Trump may score a partial victory He's not going to get probably the complete immunity that he wants, but he could probably get partial immunities depending upon how the court process plays out.
Well, thank you. And then another person wrote in and asked if President Trump does not get immunity and the prosecution is allowed to proceed with the trial, where would the trial be held, or where would it be, back to a lower court, or how would that all play out?
Normally, trials are supposed to be held in the general area where the crime occurred, so DC. The only exception to that, and the president might make this, is the claim that he doesn't believe he could get a fair trial in that venue. And then you could have, in special circumstances, the trial removed to another venue. I don't want to guess too much on that, but the assumption is in the area where the alleged crime occurred, unless you can't get a fair trial. That's something that I don't want to predict exactly how the courts would rule on that particular question, but that would be the process that they would be working out.
Well, thank you. And then does double jeopardy come into play with this at all? Is there any?
That's the accusation, or that's the claim that's being made by President Trump. It would be if he was tried to be impeached twice for the same alleged crime, or if he was subject to judicial process for the same alleged crime. But the Constitution itself says that if you're impeached and convicted or subject to impeachment, that doesn't foreclose a judicial process. So the Constitution itself says the two together don't constitute double jeopardy. It would be doing two of the same impeachment or judicial process. But the idea is one is not criminal, the other is. So not in this case, no.
Okay, well, thank you so much. I'm going to toss it back to Janine. I think she may have a few closing questions.
Oh, this has been fascinating, just truly fascinating. I am intrigued with what you just said. That's in, once again, we can pull this clause up, the Constitution. You just said that there's a clause in the Constitution that says if you're tried, within the government, you can also be tried outside the government. Have we looked at that one already? Where is that clause?
That is in the discussion of impeachments, and I'm trying to look exactly which of the discussions of impeachment that's brought up in. It's not in the presidency. It's actually how the Congress it's in Article 1, and how Congress is allowed to, what it's allowed to do under the impeachment clause. And I am, I apologize. I'm trying to find exactly where this is brought up. Because what it does, it's basically saying, what are the limits on what Congress can do when it's impeaching? It's not allowed to actually criminally prosecute someone. Okay, this is Article 1, Section 3, the very end of Section 3. And it said, I can start reading it. Judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So that's the idea that
that's the one I was looking for.
Yeah.
That's the original one I was looking for earlier.
Yeah.
Okay. So what that's saying is, and it's Article 1, Section 3.
And the very end of that article. Yeah.
Okay. Article 1, Section 3. Okay. And so what it's saying is you can get, this is exactly what I was looking for. You can go through the impeachment process, but afterwards you can still be tried again.
Their argument is it wouldn't really being tried again in the strict sense. You would be held to an impeachment process, which is just merely should you be in office anymore or again. And then the other is potential criminal or civil process where the courts decide, can you be fined or put in jail? And so
this is what's happening with Donald. That's what's happening with Donald Trump, right? He wasn't impeached.
Yeah, and the argument being made by the president is, well, I wasn't convicted, therefore I can't be tried again. But I would argue that what the Constitution is saying is, even if you are convicted and removed by the Senate, you can still be criminally liable or civilly liable if that's the case. So, and this
See,
was
I
meant
think
to,
the
yeah.
closing. Go ahead.
Oh yeah, this
Well,
was
it's
just
just
meant,
timing here.
again, meant to be a
Mhm.
limitation on Congress. So Congress can't criminally punish people. That should be left to the judicial process. Yeah.
Okay, I think my closing question for you then is, but who gets to take it to trial criminally? Like if the government within the governmental confines has decided that he's not impeached because it didn't hold up, which is still a trial in the
Yeah.
Senate, okay? If the government has already decided that, and this may be where double jeopardy could win, does the government have a right to do it again? Because it's not like Sandra Smith is suing the president, or somebody else, some corporation is suing the president. The actual government is suing the president again, or taking the president to trial again. And that's where I think double jeopardy maybe doesn't hold up.
You would have to square that with it.
Or
How
double
can the,
jeopardy does hold up. The double jeopardy does hold up.
yeah, and the question then would be, how would you interpret the idea that the Constitution at least does say, even if you were convicted and removed from office by the impeachment process, you still could be subject to indictment, trial, and conviction on the judicial side. So the question is there a way to respect that distinction that the end of Article 1, Section 3 makes, with also the question of double jeopardy? Because so yeah, that would be my question. Is you would still have to say that that second part of the end of Article 1, Section 3 means something and has an applicability, that there is some way you're subject to the judicial process without violating double jeopardy. So that would
That
be,
is so interesting because I think our founding fathers probably thought, and this is just my opinion, that this type of impeachment, which would have been something he did criminally within the government, right? Not, not something exterior against a person, place, or thing outside of the government, that they had taken care of that with the impeachment. And so it would be double jeopardy to do it again once he got out of office. And I'm repeating myself, but I mean, if he were being convicted or tried or prosecuted for something completely unrelated to the government and he was impeached for that reason or whatever, I could see that could happen. But it seems to me the government's already taken care of this issue. In
yeah.
other words, if he were being sued by Adam Carrington, or Janine Turner outside of office, then that could hold up. But this is about something that happened within the government, potentially happened within the government, as Julian George said, this hasn't even been proven yet. And he wasn't impeached for it.
Yeah, and I'll just say that again, the point to emphasize is one's opinion on these matters should not be read as what you think about the legitimacy of the actual case itself. It really is more on the separation of powers and the presidential power question. So yeah, I would say in the end, that is a legitimate question. I think I would probably read it as you can still be prosecuted, but I think the question then comes in, what's the wisdom if one process has been done, bringing in the other process? But this is why we need to take these clauses that people don't always know well or don't always come up, and air them out, and as citizens really work through and understand this isn't about merely our partisan preferences or the 2024 election or anything else like that. It really is about how the broader question of how our constitutional system works and respecting the institutions it creates and the people that fulfill those offices, how we, pardon me, do that.
Brilliant. And that's why we had you on as a guest, because you're such a perfect one to answer this. And also that's why I was really glad that we pulled up the Constitution today, because that validates your point. It really is about understanding what the Constitution has to say about it. Well said, Professor Carrington. I'm sorry I never get this into a topic. So I just find it really intriguing. And that last article was the one that I was really thinking about all along. So I'm glad we got there. Thank you. Thank you. And I'll let everybody else say thank you too. Thank you so much.
Yes,
Thank
thank you
you
so much.
very much.
Thank you. Thank you, Professor Carrington. Thank you to our audience, and we hope everybody will join us next week, Tuesday at 2:00. We're going to be looking at some more Supreme Court cases, this time on limiting unelected officials' powers, some cases that have to do with the powers of federal agencies. So we hope everyone will join us next Tuesday at 2 p.m. Thank y'all.